introduce myself. I'm Alan Bridger. I'm what Yorkshiremen call a Southern Jessie. I came from the deep south in 1969 and came to Bradford University, and I couldn't have gone to a better one for me. I was introduced to Yorkshire. I've stayed more or less here, but I still don't think I'm accepted as a Yorkshireman, even though I've lived here for 50 years. I was an actor before I became a lawyer, and then I became a solicitor eventually, long, hard, dry. And I was one of the first solicitors in the country to get higher rights. Does anybody know what higher rights is? Shout. Well, it means I had the right. Solicitors didn't have the right to go into the Crown Court and address a jury, and I was one of the first that did. So that's a bit of background. I'd make a lousy judge. I'm far too liberal. That's why they haven't appointed me. But so, anybody here want to be an advocate? I know Hannah does. Anybody else? Yeah. Great. Well, enjoy. There's nothing to worry about. I'm not, as I say, I'm not a hard judge. I must just tell you this briefly. A friend of mine is a judge, and he feeds me stories from the bench, and this is one of the funniest I've heard, and I'm going to share this with you. There was a very sarcastic judge who I'd been in front of, and a very incompetent barrister who was in front of him, and the judge was playing with the barrister a bit and said, have you considered section 36 of some completely obscure act which nobody had heard of? Are you familiar with, say, section 36? And the barrister said, Your Honour, it had crossed my mind. And the judge looked at him and said, so not a long journey then. So I won't do anything like that, but it's just, there's lots and lots of humour in the law, but not all dry. So, okay, that's the brief start. Two things I want to mention. You all know about the burden of proof, so just bear that in mind. The defence should make a lot of that, saying it's a high bar to cross. Okay. The second thing is the province of the judge is the law. So what I say goes. The advocates, the jury. I know there's not a jury today, but you have to imagine there is one. They have the right. Their authority is fact. Okay. So two things to remember. And the third thing, I promise I'm going to stop. Young advocates, or I mean inexperienced advocates, they make the mistake of always asking too many questions. So keep your questions short. Know what you want, but don't go around the houses. Just think about. And I think that's it. We can start. So good luck.
Thank you.
I'm not going to send anybody down today anyway.
Thank you, Judge, for that warm opening. We are here this afternoon in the case of the Crown versus Joe Brooks, whereby Joe Brooks has been accused of the offence of actual bodily harm, contrary to Section 45 of the Offences Against the Persons Act 1861. I beg your pardon. Is Joe Brooks present today?
Yes.
Right, Joe Brooks, you are accused that on the 18th of December 2021, you, Joe Brooks, pushed Sarah Winston vigorously on a swing with the result of Ms. Winston sustaining bodily harm. How do you plead?
Not guilty.
Thank you. And before we go any further, if I could swear you in, please just confirm to the court your full name, address and occupation.
My full name is Joe Brooks. I'm a student and I live at number 4 Ramsing Avenue, Bradford, BD7 AB.
Thank you.
I need to know the names of the other advocates.
Yes, so we've got for the prosecutor David and for the defence Hannah.
David Hannah.
No, sorry, David's surname is
AK.
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 EKE.
Thank you.
Yes.
And I know Hannah. And her surname?
Thwaites.
Waits.
Thwaites. THW.
As in the beer?
Yes.
We'll get on very well then. Okay, thank you very much.
Thank you, Your Honour. I'm just going to swear in the defendant before we proceed.
Thank you.
So if you could repeat after me. I, Joe Brooks,
I, Joe Brooks,
do solemnly, sincerely and truly
do solemnly, sincerely, and truly
declare and affirm that
declare and affirm that
the evidence I shall give
the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Right, thank you. Prosecution, over to you.
Yes. Thank you. Your Honor, members of the jury, members of the courtroom, the clerk, counsel. I am David Ben Eke, and I appear on behalf of the Crown Prosecution. My learned friend, Hannah Thwaites, appears for the defense. On the 15th of December 2022, Joe Brooks, the defendant, and Sarah Winston, the victim, were in their university spark. Joe Brooks began pushing Sarah Winston on the swing, adding more and more force and vigor as he did so. Consequently, the victim, Sarah Winston, went above the top of the swing's frame and fell to the ground, becoming unconscious at the spot and incurring a broken arm, a broken rib, and significant bruises on her face, which have left scars. The victim was also hospitalized for over 2 weeks and was in severe pain for some time. It is for this reason that we charge Joe Brooks with assault occasioning bodily harm as against Section 47 of the Offences Against the Person Act 1861, and the base crime here being battery. Your Honor, given that the main act of vigorous pushing that forms the actus reus has been established already and is not contested in this situation, I will set out in this trial, guided by the provision in Section 47, to prove the following. I will prove the mens rea element of recklessness exists here, therefore that Joe Brooks acted recklessly in pushing the victim, Sarah Winston, with so much a force that she went above the apex of the swing's frame, fell, and suffered bodily harm. I will prove in this trial that the bodily harm the victim has suffered was caused and occasioned by the reckless pushing of Joe Brooks. Reckless here, as defined in the State Against Cunningham, is Your Honor aware of the facts of that case? Can I briefly give a rundown of the facts of?
No, you wouldn't ask me that. Just say I refer to.
Okay.
You assume that.
Yes, Your Honor. Thank you. Following that, in the case of the State Against Cunningham, a defendant had removed the meter from a gas cylinder. And so, because the gas was connected to a neighboring house, when he removed the meter, the gas was open, and so it was open in the whole environment. And the woman in the other house was poisoned by it. And so, recklessness was defined in that case as, it was said that recklessness exists where a defendant foresees a risk coming from his actions and goes on to take the action nonetheless. Ms. Winston will show from the questioning what happened on that day, how she did not consent to being pushed, and the suffering she has faced consequently. Mr. Olu, the other witness, will affirm that there were serious injuries suffered by Ms. Winston and show the grave probability in general that the act could have caused that injury. Using case law and evidence, I will prove beyond reasonable doubt that the defendant acted recklessly, thus that he foresaw risk and went on with his actions nonetheless. A possible argument that could be relied upon by the defense is that my client consented to being harmed, and that would be an implied consent. This argument could go to either these two ends, and is that she consented to battery, but that would be unable to remove the liability of actual bodily harm for which her defendant has been sued. Or she may apply the road of horseplay, but my honor, I will show the absence of consent in this case and the inapplicability of any horseplay argument given the special circumstances of the case before this honorable court. As the prosecution, I ask that the court finds Joe Brooks guilty of causing Sarah Winston actual bodily harm through his reckless act of pushing her vigorously on the swing without her consent. If it pleases the court, I would now like to invite my first witness, Sarah Winston.
If you could please start by confirming your full name, occupation, and address to the court.
My name is Sarah Winston. I occupy residency at 32 Tumber Lake, Hornsey, BD7 1DQ.
Thank you. If you could repeat these words after me.
Yes.
I, Sarah Winston,
I, Sarah Winston,
do solemnly, sincerely and truly
do solemnly, sincerely and truly
declare and affirm that
declare and affirm that
the evidence that I shall give
the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
You may be seated.
Yes.
Your witness.
Hello, Sarah Winston. Please, can you tell the court what happened on the 15th of December 2022?
So, well, first of all, I am a secondary student at the university, and I study computer science. I met Joe Brooke and another friend from college at the university, and on this day, we were just messing about. We found a nearby park, and it was after lectures, so we thought, okay, let's just have some fun. So I sat on a swing, and Mr. Brooks pushed me. At first it was gentle, but then it became more vigorous, to the point where I kept telling him to stop, and I didn't want him to push me that hard, but he didn't listen to me, and eventually that resulted in me falling unconscious, I believe, because I woke up to paramedics around me, and I woke up with injuries. My right side was fractured. I had bruises and cuts all over my body, and as a result of this, I was also not able to take my exams in July. So that's what happened.
Can you describe the atmosphere of the playground that day? Was it calm, busy?
It was ordinary. There wasn't as much people there. Only a few university students, because we were on campus.
Yes. What did you do to let Joe know you no longer wanted to be pushed?
I told him to stop multiple times, to which he ignored.
So he did nothing after you told him to stop?
He didn't, because as a result I woke up unconscious. So obviously he didn't listen.
When he continued pushing you higher, was there any way you could have gotten out of the swing?
No, because at that time, with the degree and the force of the pushing, I wouldn't have able to land successfully on the ground without any harm. Like, it was so forceful and aggressive.
Can you say that Joe at that point in time knew what he was doing, pushing you even though you were saying you shouldn't?
I believe he knew what he was doing, and I believe that he also purposefully did not listen to my pleas to stop.
What has been your predicament since then, because you were unconscious and rushed to the hospital, as you said?
So on the 18th of December, I was, after I fell, it was apparent to me that I had been unconscious, because I awoke to paramedics who were attending to me, and I was in severe blinding pain on one side of my body, and my right arm was broken. And as a result, since I am right-handed, I have not been able to take my exams, and I will have to take them in July.
Has Joe apologized for this incident?
No, I don't believe he has.
Yes, thank you, Your Honor. Thank you very much.
Just one tiny point. It crops up often. You asked, was so-and-so aware? Well, the answer is you don't know, and she doesn't know what is in somebody else's mind. It's a thing that crops up from time to time in real life. Something to think about. And the way it was, you put it as a leading question. So,
yes, Your Honor.
but otherwise, it was well presented. Thank you.
Hi, Sarah. So, would you class Joe as a good friend?
Not at first.
Not at first.
No.
Since the incident or before the incident, was he a good friend before the incident occurred?
When we went to university, we became close friends.
So he was a good friend?
He was at that time.
Can you describe Joe's character to me?
I wouldn't know really how to respond to that because, you know, the nature of our relationship is just that we were close because we were at the same university. He seemed, you know, he just had the traits and qualities of what one would consider a good friend.
A good friend.
Yeah.
Brilliant, thank you. What types of activities do you, Joe and Ali, usually engage in?
So me, Mr. Brooks and Mr. Hassan, we sometimes engage in parkour activities. Skateboarding is one of them, yes.
Would it be fair to say these activities carry a risk of potential injury?
Are you referring to the parkour?
The parkour, yes.
If not executed correctly, yes.
So they do carry a risk. Has this ever stopped you taking part in the past in these activities?
I don't recall ever injuring myself with in those
But with
activities.
the fact that they have a risk to them, has that ever stopped you from participating in the activities? Knowing that they pose a risk?
No.
Would you say you visit that park regularly, with it being close to the uni?
It's an infrequent occasion where me and my friends like to go.
Would you say you were participating in a recreational activity when the accident occurred?
It indeed was a recreational activity.
Is it true you made a comment to your friends about going higher on the swing before the incident occurred?
No, I do not recall that.
Were you forced onto the swing against your will?
I don't believe so.
Can you confirm that your participation in the activity was consensual?
The participation of me swinging was consensual.
I'm having difficulty in hearing this witness. Could you perhaps ask her to keep her voice up?
Yes.
Miss Winston, have you taken any responsibility for your own safety when engaging in risky activities with your friends?
Yes.
Yeah. Can you describe to the court how Mr. Brooks pushed you on the swing? Did he come into contact with you, or was he pushing the swing itself?
I do not recall that information of where
You
he
didn't feel him
placed.
pushing you?
I didn't feel him pushing on my body, but I do remember that the degree of force that he used was enough to exert me over the apex of the frame.
Did you experience any pain or discomfort whilst using the swing?
Not whilst using the swing.
Okay. So prior to the incident, were you enjoying yourself whilst using the swing, Miss Winston?
Yes, I was.
Did Joe intend to cause you harm whilst pushing you on the swing?
Again,
I don't know his intentions.
she can't answer that because she can't say what was in his mind.
Yeah. Were there any distractions in the park at the time of the incident?
Not to my knowledge, no.
Was there a significant amount of noise in the park at the time of the day of the incident?
I don't recall it being noisy.
Okay. Did you observe any malfunction or defect in the swings that could have caused your injuries?
Not to my knowledge, there was no defect in the swing.
Okay. Was anyone else present in the park at the time of the incident?
Only me, Joe, the paramedics, and Ali Hassan.
Did any witnesses indicate that Joe was acting in a malicious or intentional manner?
Not to my knowledge. I woke up injured.
Did anyone else in the park express concern about Joe's behaviour on the swings?
Not to my knowledge, no.
And did anyone in the park attempt to intervene or stop Joe from pushing you on the swing?
Not to my knowledge, no.
Did anyone else in the park attempt to warn you or Joe about the dangers of playing on the swings the way you were?
No.
Objection, my lord. Yeah, with that, she kind of suggests there that my client had agreed to playing roughly. But my client has already said that she didn't give consent in the first place, so they weren't playing together.
She did say she gave consent.
At first, to a gentle push. Yes, Your Honor.
Did you make any attempts to get off the swing before the incident occurred?
No.
Do you have any pre-existing medical conditions that may have contributed to the severity of your injuries?
No.
Does Joe have a history of violent or aggressive behaviour towards you or others?
I would not know towards others, but not
To you?
towards me
Okay.
before that time.
Did you have any disagreements or conflicts with Joe prior to the incident?
No.
Okay. Is it true that Joe visited you in hospital after the incident?
I do not recall him coming to the hospital after the incident.
Did you have any alcohol or recreational drugs in your system at the time of the incident?
No.
Were you wearing appropriate clothing or footwear for the activity you were participating in?
I believe so.
And can you describe that footwear?
Trainers.
Trainers. Have you been in contact with Joe since the incident?
Not since the incident, no.
Okay. Did you discuss your memory of the incident with anyone else before giving your statement?
No.
No. And you did seek medical attention for your incident because you went to the hospital, didn't you?
Yes.
Yeah. Can you describe the amount of time you were unconscious for, of what you can recall?
A few minutes, not that long.
Do you believe this has impacted your ability to accurately recall the events that occurred?
I do not believe so.
Okay. But you were unconscious?
For those few minutes.
Yeah. Did you read and sign the statement that was provided to court regarding the incident?
Yes.
Yes. Can you read out the part where it states the date of the incident and what you have read and signed?
It's on the 18th of December 2021. That's the date of the incident.
Miss Winston, in your statement you said the incident took place on the 18th of December 2021, correct?
Yes.
And is it correct that the incident occurred on the 15th of December 2022?
Objection, my lord. This is an inconsistency in the whole scenario, so it's not a thing of my client's mistake.
Yes. Apologies if I could interject, Your Lord. I think that was just an error in terms of the
Hang on,
technical.
I mean, it's a fair question that you seem entitled to ask it.
No further questions, Your Honour.
So,
Yes, if I could make a point of clarification and with the apologies of the court, when the documents were printed, there appears to be an error in the statement of Sarah Winston, which should read the same date as all the other, which should all be the 18th of December. So there has been a bit of an error with the documents. So my apologies, the court's apologies with the documents that were sent out.
well,
Yes, I have some.
we need to have a separate trial in relation to that matter. How it came about.
I have some. Yes, Sarah. With just to clarify for the court, her question about your friendship with Joe before this day, could that have been why you allowed him push you gently at first?
Yes, because I didn't expect for him to push me in such a manner.
Yeah. And you also said you participate in parkour activities. Can you describe parkour activities?
So parkour activities, you know, free jumping, mainly. There's a range of parkour activities that one can be involved in. You have different levels: beginner, intermediate, and advanced. And
Do you do parkour alone, by yourself? So you don't need someone to push you for parkour?
no, not at all. It's an independent activity.
Yes. So every risk that comes with your jumping or flipping is all from you?
It's on my own accord, yes.
That would be all my honor. And I would like to call...
I've just got one more question.
I think once we've done the exam, we can.
Oh, can you not go back?
Well, you can ask him. Ask me, you have another question.
Just one more. That's
Well,
all.
hang on, you'd have to ask him, you'd have to get consent from the prosecutor.
Will I
ask
be
me
able to
or
ask
to
one more
ask her?
question?
Oh no, I don't think we have a chance now. The cross-examination is open for that, and so all questions should be put forward.
Thank you.
Yes. Thank you, Ms. Sarah. Your Honor.
Actually, as this problem issued with the date, what would happen in real life if the barrister had read both the prosecutor and the defence and they read the papers? They'd have sorted this out before the trial.
No, Your Honor. The inconsistency is also on the scenario.
In real life.
Yeah.
It's also on the scenario sheet, so it's not just the witness statements. That's why it's...
Well, all right, well, let's not go down too far, but I'm saying you would just, the prosecution and the defence would agree that there'd been, or not agree, and if they couldn't agree, then in the absence of the jury, I'd have to deal with it.
Yeah.
Yeah? Now, both of you done very well. It's just a principle that, you know, you said, did anybody else, were the people in the park, did they say anything? The danger with that, Hannah, is this: you don't know. Supposing supposing she says yes, they did. You're snookered, and we've all done it. You're doing all right, and then and I'll give you a story. I'll tell you something that happened. You're a hostage to fortune. What you can do is say in your final speech, there is no evidence that anybody else. We have evidence that the people in the park, but we have no evidence that they protested or whatever or warned anybody. Do you see? You can still use it,
Yeah.
but it's dangerous territory.
Okay.
You got the point?
Yeah.
If she'd said yes, or dozens of them that said warn, then anyway, I'll
Thank you.
remind me to tell you a very entertaining story where somebody went wrong. In fact, I'm going to tell you now, and I should probably be told off for a very brief story. This involved a burglary of a quad in Oxford, and the police had said that the defendant hadn't been seen not to have been alerted. The defendant was in the property, right? So. So the defence say, right, to the police officer, how tall are you? And how much you were, 18 stone. And was it quiet? Yes, it was quiet. And you had your regulation police boots on, yes. And you're on tarmac, yes. Great, doing well. All going in the final speech. This is the question, and knackers him and says, how can you explain that you approached him, you set the whole thing up, heavy boots, heavy man, quiet, set the whole thing up and says, how can you explain, this is where he goes wrong, how the defendant wouldn't have been alerted to you? Police says, because I was riding a bicycle. Ah! Do you see the point? And it's so easy, it's so tempting. All he had to say was, all the defence had to say in the final speeches, it doesn't make sense. It's too late for the prosecution to come back and say, well, he was on his bicycle. So that's why I make that point. And now so let's crack on, because otherwise I'll be told off for spending too much time. But it's a good illustration of how things can go wrong. And you say you shouldn't ask a question you don't know the answer to. But anyway, there it is. So let's crack on.
Thank you, Your Honour. Thank you, Sarah. Yes.
Yeah.
Your Honour, can I invite my second witness,
Yes.
Mr. Olu, Femi?
My name is Femi Olu,
And if you could confirm to the court your address and
Yeah.
occupation, please.
1 Humboldt, The Green, BD7, 1BP.
Right, thank you. If you could repeat these words after me. I, Femi Olu,
I, Femi Olu,
solemnly and sincerely and truly
solemnly and sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the
and
truth.
nothing but the truth.
And you may be seated.
Hello, Mr. Femi. What do you do for a living?
Yeah, so I am a paramedic at West Yorkshire General Infirmary, and I've been working there for the past 5 years.
Where were you when you received the call?
On the Thursday, the 18th of December, I was on the road to Ladi to work at the ambulance station, and I was grabbing a cup of tea with my colleagues rather, and then I got the call that someone had been injured at the playground, and then I got there within the first few minutes of getting the call.
Where was Sarah Winston when you arrived?
When I arrived, she was on the ground, laid unconscious on the ground when I arrived, and I saw her there.
Can you describe her state aside the being unconscious? Were there injuries?
Yes, she was bleeding, her face was bleeding when I got there. She was clearly unconscious, so she could not respond. So I placed her in the recovering position. Immediately I found her on the ground.
Were there people around her?
Yes, there were people. When I first got there were a couple of young men around her, and there were people around her saying that, oh, she'd fallen, she was swinging, she was on the swing and she'd fallen from the swing, and that was the cause of her injuries.
Can you identify those people, those men?
No, I could not recall. There were people there, so many people there, so I couldn't recall. I couldn't get a name, and I can't remember her face.
Seeing the injuries and that she was unconscious, hearing that she was swinging, does it sound probable that swinging will cause?
Yes, because she was swinging from a very high, the apex of the frame of the swing, so then she fell down. So yes, it could probably cause the injuries.
And did anyone follow you to where you carried her?
No, we placed her on the stretcher after we found her. Then after we placed her on the stretcher, we took her to the hospital for examination. The work surgeon general friendly for examination after we found her. So no one followed us, just I and my colleagues got there. Then I stayed with her when she was in the hospital. And
did anyone come?
yeah, her parents came afterwards.
Just her parents?
Yes.
Okay. Thank you very much, Mr. Olu.
Thank you.
Hello, Femi.
Hi.
So, what kind of injuries did you observe on Sarah?
So while she was unconscious, she woke up a few minutes later, and then she complained about pains in her right arm and the right side of her chest. So from there, I was able to deduce that she probably had fractured a few of her ribs and her right arm as well.
Did you personally ask Sarah how she sustained her injuries?
No, because she was unconscious. I didn't ask her. From what people were saying, I could just guess
She was
that
unconscious before,
Yes.
just as you were coming, but did you ask her when she was conscious how she sustained them?
No, I didn't ask her, but I could deduce from what people were saying that she had fallen from the...
Did you observe any signs of intoxication or impairment in Sarah or Joe?
No.
Did Joe seem genuinely concerned for Sarah's welfare?
I do not know who Joe is. I just went there, saw a few young men.
So, you mentioned there was 2 males present at the
There were a
time.
few young
A few.
men. So
Did any of them not seem concerned?
They did seem concerned, but no one necessarily asked or anything.
Can you describe the noise level and activity in the park at the time you arrived?
Yeah, there were a few people there. They were all kind of rowdy, but it wasn't necessarily
So
very...
it was quite rowdy, you say?
Yes, quite rowdy.
Yeah. Did the noise and the activity in the park make it difficult for you to communicate effectively?
No, we did not.
No? Okay. Can you describe the typical use of the swings in the park?
Typical use of the swings, well, it's a playground, so people... what do you use to swing for you? So it's not necessarily anything out of order to use a swing on the park.
Can you just bear with me. How long after the incident did you arrive at the scene?
A few minutes after the first
A few minutes after it
yes.
happened. Brilliant. Were Sarah's injuries consistent with falling off a swing?
Yes, she broke her arm and her ribs, so that's consistent with falling off a swing.
Okay. Can you describe the weather conditions at the park at the time?
It was normal, typical weather. There was nothing, it wasn't raining, it was just snowing.
Sunny?
Yeah, sunny.
Sunny? Okay. Okay. Have the park received any complaints or concerns about the safety of the swings before?
I do not know. I'm a paramedic, so I won't be aware.
But in your statement, you say that you sort of monitor that area regularly as a paramedic. So
I mean,
Objection, my lord. I don't think it will be the job of my witness, who is a paramedic, to seek whether things are safe on the playground, but it will be the job of other people that are actually in charge of the playground in the university.
Well, the defence is simply asking, is she aware of any other incidents? And
any incidents or injuries that have occurred?
and as she
in the
patrols
park
the area,
previously?
I think it's a fair question.
Okay, ma'am.
Can you provide an estimate of how many times you have responded to the park, calls to the park related to incidents on the swings?
I do not recall how many times I have.
Based on your observations, do you believe, and your experience, do you believe that actions of Joe were direct cause of Sarah's injuries?
Yes,
Yeah.
I do believe that.
And you just mentioned previously to the prosecutor that Sarah was swinging high.
Yeah.
You weren't there when it happened, were you?
Well, people around me, around there were saying that, oh shit, swinging high. So
Objection, my lord. That is hearsay evidence, and we can't rely on that.
No further questions, Your Honour.
Yes, Mr. Femi, just to clarify with you, is it given within your job description that you ask victims of whatever dilemma what caused their injury?
yes, it
Okay.
is.
the concerned individuals around, the faces that you saw that were concerned, you don't know them, do you?
No. I was focused on the victim, so.
That will be all, my lord. Thank you, Mr. Olu.
Thank you.
That's the submission of the prosecution, my lord.
Thank you very much.
Basically, defense would like to call.
Your Honour, I'd like to call my first witness, Joe Brooks.
The defendant has already been sworn in, so no witness.
Hello, Joe. Can you describe your relationship with Sarah and Ali?
Yeah, we're good friends from high school, from sixth form to the university. We've been very good friends.
Yeah. What types of activity do you, Sarah and Ali, you usually engage in?
Yeah, I must say that Sarah presents as a tomboy, and we always have some physical or, if you like, very active plays. Sometimes we go on the swing, sometimes we play football sometimes. Very physical exercises, yeah.
Would it be fair to say these activities carry a risk of potential injury?
Of course, there are contact activities or sports, and sometimes we get injured, sometimes we don't.
Has this ever stopped you from consenting to participation?
No, we always carry on. It's one of those things, isn't it?
So, has Sarah, Ali, or you ever attempted to perform any dangerous or reckless stunts on the swings before the incident?
Of course, we've tried many things, including performing dangerous stunts and all that. Beyond that, we've always dreamt of taking risk, and seeing how we can come out of those risks. So yes, we do.
So how often would you say you participate in these recreational activities with Sarah and Ali?
Many times.
Many times?
Yeah.
Did Sarah specifically ask you to push her on the swings?
Yes, Sarah actually, before then, had wished to, go on a swing, and on a very, also wanted to be pushed very high, because I could remember there was a time when we were, we saw a movie together, and in that movie, someone was being pushed very high in a swing, and she wished that she would want to be pushed that high and see what kind of risk, or generally see what will come out of it. And so yes, she actually consented for her to be pushed in that.
Did you have any intention of causing harm to Sarah when you were pushing her on the swing?
No, not at all. Not at all. Sarah has been my good friend, and I've never thought of hurting her in any way, shape or form. No.
Can you describe the level of noise and distractions in the park on the day of the incident?
It was very noisy. It was very noisy, and as you can imagine, a lot of distractions, and yeah, it was very, very, very noisy. It was.
Okay.
We could barely hear ourselves sometimes.
Did anyone else participate in pushing Sarah on the swings before the incident occurred?
Just myself.
Just you. Okay. How long were you pushing Sarah on the swings before the incident occurred?
For some minutes. I can't really.
Minutes?
I didn't really keep time.
Did you attempt to stop pushing Sarah on the swing before the swing went above the apex of the frame?
No, because at some point I actually asked Sarah if she was enjoying it, and she nodded. And to my mind, I thought that was a signal, that was a plus for me to carry on doing what I was doing.
Okay. Did you try to catch Sarah when she fell off the swing?
I can't remember trying to do that, but I just saw that Sarah had just fallen off the swing.
Can you describe your emotional state after the incident occurred?
I felt very sorry. I felt very bad of myself, having pushed someone to that extent. So I really felt very bad, and I ran to Sarah myself to see what I could do immediately after I saw her on the floor.
Okay. Were you under the influence of any substances or alcohol at the time?
No.
No. Okay. Did Sarah express any discomfort or fear before the incident occurred?
No, not to my knowledge.
Did you express any discomfort or fear before the incident occurred?
No, no.
No. Would it be fair to say that due to the background noise and distractions that this could have potentially caused an issue with communication between you both?
Of course, that was an issue because we barely heard what we were saying to each other, and it was very noisy. And so I can't remember Sarah saying no to when I asked her the question. She was just smiling and with a nod.
Did you have any previous altercations or disagreements with Sarah before the incident occurred?
No,
No.
we've never had a kind of altercation or disagreement.
Can you describe your personality and temperament in general?
Well, we all have our naughty moments, isn't it? And so sometimes, yes, but generally I would say I'm very calm. I'm not violent. I've never had any record of assaulting anybody whatsoever, and I've always been known as a good person in the community. Yeah.
Do you consider yourself a responsible and cautious person?
I'm a responsible person.
How do you handle stressful or challenging situations?
Well, I try my best not to escalate issues when I'm stressed. And so, yes, I can say I can manage stress. But yes, we're all human, so we manage stress differently, but I know I have a good level of managing my stress.
Did you or Sarah or Ali check the condition of the swing, and were you aware of any malfunctions or defects?
No, there was no such.
None at all?
No.
Did anyone else witness the incident or the events leading up to it?
I believe people in the park, they witnessed what happened. I believe many persons within that, within that space, they witnessed what happened, and yeah.
Okay. Can you describe your level of experience and expertise in recreational activities such as skateboarding and parkour?
Yes, so we've been doing this for a long time now, so I can really say that we've got that experience and we've got that expertise when it comes to physical exercises or activities, so yeah.
Can you describe any other incidents or accidents that have occurred in the park before this incident?
On that particular day?
No, previous.
Previous,
When
yes.
anything happened
we've
with
had,
recreational activities?
yes, we've had incidents where playing football or on a skateboard where someone tipped over and sustained some minor injuries and all that. It wasn't that serious anyways.
Do you have any previous criminal convictions or legal issues before the incident?
No, not
None
at all.
Did you cooperate fully with the police and legal authorities during the investigation?
Of course, yes.
Did you visit Sarah after the incident occurred?
Yes, I did.
Did you take Sarah a gift? If so, what?
I visited her and I can't really recall. No.
Can't remember. Are you a well-respected member of your community?
Yes, I am.
How?
Yes, so I'm involved in some volunteering, I'm involved in some charity work, and I also raise funds for the charity that I volunteer for.
Thank you. Did Sarah say anything after falling off the swing?
No, she didn't
No.
say anything.
Did she indicate whether she was in pain or not?
Yes, I could see that she was in some kind of trauma.
Did she accuse you of intentionally pushing her off the swing?
No, she couldn't talk at the time.
Okay. Did you express remorse for what happened?
Of course I did.
Have you stayed in touch with Sarah since the incident?
Yes, I visited her a couple of times in
Couple of times.
the hospital.
Was this a deliberate act to cause harm recklessly and intentionally to Sarah, or was this an accident?
Purely an accident, not intentional.
No further questions, Your Honour.
Yes, Your Honor. Hello, Mr. Brooks. You, Sarah, and your other friends have, as you said, engaged in risky activities before.
Yes.
Is that so?
Yes.
And you describe this kind of activity as daring activity in your witness statement.
It is daring.
Please, can you explain what you mean by daring?
So there are activities that carry some kind of dangers in the consequences. So there are activities that anything could happen. It could cause you some injuries. Sometimes it could even cause life. Sometimes.
So a daring activity is one that has the element of danger
Yes.
to it.
Yes.
It's
High
being
risk of
pushed.
danger.
Yeah, it's being pushed very high on the swing. One of those activities that has danger.
Yes, it's daring to push high on the swing.
And were you aware of this at that time?
Yes, because it's not the first time it's not the first time we've engaged in such activity. It's not the first time that we've come out without any form of injury, having engaged in such daring activity.
Coming back to this time, did she agree to being pushed high? Did
Prior-
she say so?
Prior to, yes. Prior to, I say yes because we saw a movie together where someone was being pushed in a swing, and she wished that she would, be one day pushed very high, even higher. And on that particular day, I remember asking her if she's okay, and she smiled and nodded. So I
No,
thought,
just to be clear, did her saying so in earlier on, is it stating she wanted to be pushed? Has she stated she wanted to be pushed?
yes. So when she got on the swing, she wanted me
On
to
that
push
day.
her. Yeah.
Yes, so how did you ask her? Can you describe it? I mean, actually show us how you asked her.
So
I mean, imagine you're there again, she's on the swing. Show us how you asked her.
do you want me to? Do you
Yes.
want me to push you on this swing?
No, I want you to show us. Speak. Ask us how you asked her.
Exactly what I'm saying. Oh, Sarah, do you want me to push you on this swing? And she said yes.
Was it with that tone?
Well, I can't really mimic the tone, to be honest. So, yeah, in terms of tone, I can't mimic, but I can still recollect exactly how and what happened.
While examined by the defense, you said the playground was noisy.
Yes, it was.
How then did you think it fit to ask a question when it was noisy and you couldn't hear each other? As you said
We
earlier
were,
as well.
we were in close proximity. I was just right behind her.
But you said you couldn't hear each other earlier on.
No, that was when the pushing started. Before you
So
asked
you
the
could
question,
hear-
before the pushing. So before the
No, no,
pushing, we could hear each other because, sorry, Your Honor, if I could just demonstrate that. So she was sat on the seat on the swing, and I was just behind her, and I said, "Do you want me to push you?" And she said, "Yes." And so I started pushing. So at that point, we could hear each other because it was close proximity. My honor.
You said, initially, I was pushing gently.
Yes.
And then I
I
remembered.
think we're going beyond the re-examination. You're not under re-examination. You're not entitled to
And re-examination.
Cross-examination.
Cross-examination, yes. May I continue, Your Honor?
yeah.
Thank you. So, Mr. Brooks, initially, you said, initially I was pushing gently, and then I remembered. So your remembering came after you were already pushing. So she was in motion when you asked that question, wasn't she?
No, she was not in motion when I started pushing. She was still when I started pushing because as she sat, then I went to her and asked if she would want me to push her, and she said yes.
So she was static when you were pushing gently.
No. So when she sat on the swing, I went there. It was just a bit shaky. It wasn't really moving at that point where you would want to enjoy a swing. And
There's a discrepancy between what you're saying and what you've given, because you were already pushing before you remembered in your witness statement, but you claim now that you hadn't been pushing before you asked.
So if I have to put the record straight, she sat on the swing, and I went to her. Would you like me to push? And she said
So
yes.
you asked before pushing at
Exactly.
all.
Yes, and so it was a gentle push. We started off, and then we increased the momentum.
Do you realize that is different from what you've given? Because here you said you had already been pushing, and then you asked you had already been pushing. But now you say you asked before starting to push at all. So are you agreeing that there is a
I
discrepancy
think
between what
again,
you're saying?
you are going beyond re-examination. This is not about clarification of.
No, I'm cross-examining Your Honor.
Cross-examination, Your Honor.
May I continue?
Right.
Thank you, Your Honor. Moving on from that discrepancy, as has been identified, you claim you saw her nod to your question,
Yes.
and you've already agreed that the place was noisy. when you asked the question.
Yes.
Where were you standing when you asked that question?
Behind
Sarah.
her, behind Sarah, yeah, behind the swing.
Can you describe the swing? Does it move upwards, downwards, or side to side?
Upwards,
Downwards.
downwards.
Do you agree with me that there's a possibility that her head was moving with the rest of her body as she went up and down? Because it's not going this way. It's going this way.
I'm not sure if I can't say yes.
But would it move this way if you're being pushed this way? If you were on the swing, would you move this way or would you go up
I'll
and down?
go up and down.
Do you believe that if I'm pushing you on the swing, for example, your head may move with your body up and down? Do you believe that? Yes. Or no?
Not in all cases.
But is there a possibility that that can happen?
There's a possibility.
Thank you. You also say you saw her smiling,
Yes.
and as you said earlier, you were standing behind her.
Yes.
Can you explain to the court how you could construe a smile from behind her?
Yeah,
Did
she
turn
turned.
back?
She turned.
Mm.
She turned at me, and that was how I saw her.
And was she saying anything when you were pushing vigorously?
No, she didn't say anything.
And you were pushing her vigorously, and she turned back without falling.
Yes.
Mm. Has Sarah ever pushed you vigorously on the swing?
Not that I can recall.
Have you ever reached the apex of the swing string before
Yes.
by yourself?
Not by myself.
Were you pushed
By
by
someone
someone,
pushing me.
okay, someone else,
Yes.
but not Sarah?
Not saying.
That will be all, Your Honor.
Thank you.
Thank you.
No further questions.
Thank you.
Your Honour, I'd like to call my second witness, Ali Hassan.
If you could confirm your full name, address, and occupation to the court.
Yes, Ali Hassan, number 12, London Road, Leeds, LS 014PJ.
Thank you. And if you could repeat these words after me. I, Ali Hassan,
I, Ali Hassan,
do solemnly, sincerely, and truly
do solemnly, sincerely, and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence that I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. You may be seated.
Thank you.
Your witness.
Hello. Can you tell us your relationship with the defendant, Joe?
Yeah, I've known Jen since school, so we've known one another quite a few years, yeah.
Have you known Sarah long?
We knew her at school, so we were in the same sort of classes. I think computer science was one of them, so we knew one another, but sort of grew closer at university.
Did all three of you have a good relationship?
Yeah, we got on. We went skateboarding, so I used to go quite regularly to the skateboarding park. Joe, Sarah, probably once a fortnight, probably.
Yeah.
But yeah, we that's how we sort of bonded.
How would you describe Joe's personality?
Yeah, he's a great lad. He's always up for a laugh.
Yeah.
Bit of a daredevil like me, you know, with the skating and everything else. So.
Yeah. And what activities do you usually engage in?
Well, the skateboarding, we hang around the park quite a bit. So what we not usually like to do is sort of go on the merry-go-round, see how quickly we can go on the swings. You know, it's a bit of an adrenaline junkie thing that we do.
Can you please describe the events leading up to the incident for me?
Yeah, so it was the final week of term, just before we were breaking up for Christmas. We'd finished classes, we were all down at the park, very busy. Someone had got some music on, and I remember, because it was my favourite song, it was Slade, you know, Christmas. So that I was paying attention to that, but Sarah was on the swing, Joe was pushing her, and, you know, between everything I kept looking over, they were having a great time. I think at one point Sarah was sort of, you know, waving her hands a bit as though, you know, go higher. And then when I looked over again, someone screamed and Sarah was on the ground.
Okay. Have you been to the park before with Sarah and Joe?
Yeah, we go quite regularly. As I say, we go on the merry-go-round, go on the swings, see how high we can go, see how quickly we can turn the merry-go-round, hang out a little bit, get it going really quick.
Can you describe the noise in the park at the time of the incident for me?
Well, it was busy, normal murmurings. As I said, the people were singing along to the music as well,
Yeah.
so it was quite noisy.
Was Joe pushing Sarah higher than he had done before?
We've all gone high on this swing, and yeah, I suppose on that day possibly going higher, but I think it was one of those things where every time we go, we try and go quicker, higher,
Yeah.
you know, just one of those things.
Was Joe acting any differently on the day of the incident?
No, we were all the same.
Yeah.
If anything, we've altered a little bit afterwards, because Sarah's been a bit standoffish, so I've given her some space to sort of get over it, but yeah.
Did you notice anything out of the ordinary on the day of the incident?
No, not really. It was pretty normal.
Were there any warning signs of potential dangers of using a swing in the park that you saw?
Not that I've seen. It is quite an old park, so we've been on them before. We always joke about them being a bit squeaky. That's about it. It's, you know, but yeah, we've been on there loads of times.
Did Sarah express any concerns about the height at which Joe was pushing her, or did you hear her express any
I
concerns?
didn't hear that. All I said was I could see her wave her hands at one point. They seemed to be enjoying themselves. I sort of wandered off to one side.
Were they both laughing and having fun?
I thought they were having fun, so yeah. It's,
So they were laughing.
yeah, there
Having fun.
wasn't any sort of animosity that I could see.
Did Joe say or do anything to suggest that he intended to harm Sarah, to you?
No, not at all. We're close pals. We've been very close for the last couple of years since university. That's where we really bonded, but we've known one another for ages.
Did Sarah appear to be scared or uncomfortable on the swing?
Scared? No. Uncomfortable? Well, when you're pushing yourself to the limit, you know, you're really going for that sort of quicker, higher, then yeah, there is an edge to it, but that's what gives us the kicks.
Did Sarah tell Joe to stop pushing her on the swing at any point? of
I
what you
didn't
know?
hear that, no.
Okay. Did you witness the moment Sarah fell?
No, as I say, I was over to one side, listening to Slade, and then I heard a scream, and that's when I looked over. I saw Sarah on the ground. Immediately, Joe was over there. I ran over there. I phoned the ambulance, and we were both sort of shouting her name. So, Sarah, Sarah, and she just wasn't responding. She was, I assume, unconscious. We were really worried, and then the paramedics came.
So did you see what actually caused her to fall off the swing?
No.
No. Okay. Did Sarah appear to be injured immediately after the incident?
She was laying there, she was unconscious. As I said, we were shouting to her, Sarah, Sarah. But, you know, we've all done our health and safety at uni, and we didn't want to touch her or move her just in case. So we left her, called the ambulance, and stayed with her.
Did Sarah have a history of being injured or accident prone when engaging in these types of activities with you guys?
I think we've all sort of scraped the skin off our sort of elbows and knees and everything else, doing skateboarding and that sort of stuff, falling off the merry-go-round. That's part of it.
Did Joe appear to be concerned when Sarah's had fallen?
Yeah, he looked like the life had drained out of him. He really did look very shocked. We both were.
Mm-hmm. Did he immediately rush to Sarah's aid after she fell?
Yeah. As I said, he was closer. He was there first, sort of, you know, shouting her name. Really, really worried.
Did Sarah say anything after falling off the swing?
Well, she was unconscious,
When
but
she came round?
she was very drowsy, very disoriented. I think that's when we sort of took a step back and let the paramedics deal with her.
Did Sarah accuse Joe of intentionally pushing her off the swing?
Not at the time, no.
Did Joe seem surprised or shocked when Sarah fell?
As I said, looked like the life had drained out of him. He was very, very shocked.
Did Joe seem remorseful for what had happened?
I think he did, and when we talked later, he couldn't think of anything else. He was absolutely heartbroken, gutted.
Did Joe seem to be acting in a malicious or reckless manner at any point?
No, we were doing what we've done loads of times.
Did either of them seem to be under the influence in your impression?
No.
Have you stayed in touch with Sarah since the incident?
I know that Joe has. I gave her a bit of space. She, as I said, she has sort of been a little standoffish since, so decided to give her some space.
Do you believe Joe intentionally and maliciously inflicted these injuries on Sarah?
No, not at all. Joe's pushed me on the swing. I've pushed him and Sarah. No, we're just doing what we always have done.
No further questions, Your Honour?
Yes. Hello, Mr. Hassan.
Hello.
Do you guys push each other during any other game in the playground apart from swinging?
We do the merry-go-round, so we grab the metal, we push one another, so yeah.
You've said on the merry-go-round you check who can push faster.
Yes, and we also sort of hang out a little bit to get the speed going, so yeah.
Have you ever been pushed to the height that Sarah was pushed?
No, but I suppose I'm a bit heavier than Sarah, so...
Have you ever pushed Sarah
yes,
to that height before?
not to that height. Joe's a bit stronger than me, but yeah, we always give it our go. So we push them on the back, and then as it's getting a bit higher, get a hold of the seat and sort of push there.
Do you think it's safe to be pushed to that height?
Well, I suppose as we've gone higher and higher over the months, you know, nothing has happened. So yeah, we've sort of continued with it. It's a bit like skateboarding, you know. You're trying new tricks, you're pushing it to the limit, and you know, sometimes it works, sometimes you take a tumble and try again.
Where were you standing?
Over to one side, so I was keeping away because the swing was sort of moving around, so moved over. A friend got some music going, and as I said, you know...
So was that on the other end? Because you said you ran over, so it was sort of away from the swing.
Okay, out of the vicinity of the swings, but yeah, over to one
it
side.
was over to another side. Yeah. And was your sight, could you see very clearly?
I could see, but there were people coming and going, so I couldn't see directly all the
Everything
time.
very well, yeah. And you described this wave of Sarah's. You said you saw her wave her hands.
I sort of go higher.
So how was it? Both of her hands?
I
Can you
can't really
describe
remember
it?
from the angle. I can certainly see one.
Okay,
and,
okay.
You know,
Could the other one have been out as well?
I don't know.
Okay.
Possible from what I saw.
Do you consider from that wave that you saw, because you were very quick to say push higher, so do you also consider that, you know, while she was being pushed so forcefully, she may have been trying to catch herself, her hands may have been flaying because she was being pushed with so much force? Don't you consider those as well?
I suppose from my own experience, if I'm going very high, I grab on.
Okay.
She was actually waving.
I mean as if to fall, waving as if to fall. Don't you think it may as well be that? Do you consider it may as well be that?
Not really, because if she was going to fall, she'd be hanging on to secure herself. The reason I remember it is because it was such a universal language, sort of higher. So I can only assume it was she felt safe, but I don't know.
But in all your games, I mean, you've played numerous games with Sarah and
yeah, she's
Joe.
an adrenaline junkie like the rest of us.
Have you ever played this particular game of pushing
The swing?
to the swing? Because you said the merry-go-round in your witness
Yeah,
statement. Well, you didn't quite say
with the merry-go-round, we try and go faster. With the swing, we try and go higher.
higher.
Yeah.
Okay,
so,
very high as well.
Yeah.
And there is a risk that has, I mean, with a daring game.
Exactly. There's always a risk.
That will be all, Your Honor. Thank you.
So, do you recall watching someone being pushed high on the swing?
Before or on that day?
Do you recall watching someone before that day?
Yes.
Yeah. Did Sarah make any comment regarding this?
No, not negative. We were all sort of slapping one another on the back as to how high and how fast we can go.
So in early December, you were with Joe and Sarah and you were watching someone being pushed high on a swing. Can you recall the comments Sarah had made?
Can't really remember that, but I know we've always wanted to push it to the edge.
So you said earlier the swing was squeaky.
Yes, yeah.
Can you confirm if you've noticed any defects in that swing?
It's old, it's rusty, it squeaks, but you know, everything in that playground does. You know, nothing's happened so far.
No further questions, Your Honour?
I think we can move to closing statements,
Yeah.
Your Honour.
If you want some time. to
Yes,
go
Your
through
Honor. 1 minute would be very helpful. Thank you.
If you're ready, sir, the court
Yes.
will push for time.
Thank you. Thank you for that time, Your Honor. Your Honor, members of the jury, as the prosecution for the state, it is imperative in my position to seek the best for society. Therefore, I analyze cases without bias or without a forceful thought that a crime must go a particular way. Having seen the facts and evidence, I have not sought to prove that the defendant intentionally caused my client harm. Instead, Your Honor, as I stated earlier, I have set out to prove that the defendant, Joe Brooks, acted recklessly and caused bodily harm to my client. According to, again, the case I mentioned earlier, the State and Cunningham, recklessness is there where a defendant has foreseen a risk emanating from his action and yet proceeds to take that action. Defendant Joe, during the questioning, admitted to the daring nature of pushing someone very high on a swing. This is admitting to a subjective view that what he was doing was dangerous. He further admitted that there are other daring activities and that there are possibilities of injuries with these activities. But despite this possibility of risk on his part in this particular matter, that is, with this game of pushing high on a swing, Joe Brooks decided to undertake his action nonetheless, thus proving that he acted recklessly. The harm my client has suffered has been evidenced by the witness, Femi Olu, and is not a contested fact in this case. Sarah suffered injuries from a fall caused by Joe Brooks's reckless and vigorous pushing. He initiated that fall. With this, I have satisfied the provisions of Section 47 of the Offences Against the Person Act 1861, having shown that Joe Brooks acted recklessly, that is, he saw it was risky to push so high and yet continued. And I've also satisfied it by showing that his reckless act caused the injury. The defense may propose that my client consented to being pushed, but as my client has said, she did not consent to being pushed vigorously. She did not mind when the push was gentle, which was not far-fetched. I mean, he was her friend. However, once she noticed it was becoming vigorous, she did all within her power at the time to let him know. She couldn't have left the swing while it was in motion, as she said, because that in itself would cause her injury. As in the case of H against CPS, where a teacher that agreed to teach in a special needs school had been assaulted by an ADHD student, a student suffering from ADHD, the court held that the teacher's agreement to teach in a special needs school could not be seen as an implied consent to violence. Analyzing the present scenario in light of that, my client cannot be said to have consented simply because she did not mind being pushed gently. She didn't mind being pushed gently, but she didn't want to be pushed vigorously. Vigorous pushing, such that gets an individual up to the apex of his swing, is akin to violence, especially seeing the grave risks that come with that. Your Honor, in this case, my client cannot be said to have implied consent to Mr. Brooks' vigorous pushing, but instead she consented to being pushed gently. Furthermore, the indications of consent given by the defense witnesses have proven to be utterly unreliable. The nod of my client, which Mr. Brooks claims was an action in response to his question, despite the generally agreed noisiness of the playground and the apparent possibility that my client's head was simply moving upwards and downwards as the rest of her body was. The smile of my client that Mr. Brooks claims to have seen from behind my client, which, as I have said before, is utterly improbable. You don't see a mouth when they are facing front. The way of my client, which Mr. Hassan claims to have seen, again, agreeably an action that could have indicated she trying to gain her balance while on the swing, or was being pushed with such a force that her hands flailed while she was on the swing. Your Honor, these are unreliable indications of consent and cannot be used as basis to prove my client consented. The defense may perhaps also propose that there was an implied consent that arose from past rough play, hence the horseplay argument. However, Your Honor, there are significant distinctions between the present case and other cases of horseplay which I would like to make clear. From these distinctions that I seek to make clear, I submit that there would be no need for the court to apply the exception of horseplay to the general rule that individuals cannot consent to actual bodily harm, but only to battery. The exception would be that the defendant need not reasonably believe in consent, but only a genuine belief is needed. These distinctions I will present now show why the horseplay argument shouldn't be considered at all here. In cases of horseplay, the most used cases of horseplay in court, for example, Jones and Aitken, Jones being one where schoolboys were beating each other as they usually do for birthdays, and Aitken being one where army officials were setting fire to themselves, all of them cooperatively doing so. And as I said, in Jones, the boys had roughly played that particular game before, that is, beating each other. Hence, a ground with which to imply consent from the past. In Aitken, all the individuals remained in the vicinity of the rough activity even when they could leave. In the present case, as has been confirmed from evidence, my client, Joe Brooks and Ali Hassan, have never indulged in the rough game of vigorously pushing each other above the apex of the swing. They have played the rough game of pushing each other fast on the merry-go-round, and any reasonable adult would understand the difference in risks between being pushed fast on the merry-go-round and going so high on the swing. Unlike in Aitken, my client couldn't leave the vicinity of the dangerous activity. Thus, it can't be implied by the defense that she was okay with the vigorous pushing since she could have left the swing. No, she couldn't have left without getting injured. Therefore, her remaining on the swing cannot and should not be taken as an implied consent to rough play. Other distinctions exist, such as the fact that this was not a game of mutual risks. She was the only one on the swing at that time, and she could not come down and start pushing because it was not even agreed to be so. A better case to use is that of the state against A, where two boys who claimed to be playing roughly and who claimed that the victim had consented to it had pushed this victim into the water, and the victim drowned. The victim, it was provided to the court that there was proof that he had not, in fact, given a consent. He had shown to the best of his own power that he was not ready to swim because he couldn't swim. Your Honor, she has not given consent in this case, the same way that victim in that case hadn't given consent. The friends who were playing horseplay and who claimed to be playing horseplay had not gotten the consent of the person that suffered, in that case died. But here, suffered injury, being unconscious, breaking a rib, breaking an arm, not writing exams, having to read for exams which would have had off her head right now. And these things come together to show the predicament that my own client has been put in without any consent being given from her. Your Honor, having provided evidence that proves beyond reasonable doubt the recklessness of the defendant and shown the lack of substance in any likely defense, my respectful submission is that you find Mr. Brooks guilty for inflicting actual bodily harm on Ms. Winston on the ground of recklessness. With that, I end my submission, Your Honor. Thank you.
Your Honour, members of the jury, today you have heard testimony from 4 individuals about the incident involving Joe Brooks and his friend Sarah Winston. We have heard that Joe was with his friends Sarah and Ali in the park on the day in question. They were engaging in a recreational activity that is enjoyed by millions of people around the world, swinging on a swing. This was a moment of innocent fun, something they had done before without any issues or incidents. We know that Sarah suffered injuries whilst playing on this swing in the park, and we sympathise with her for what she has been through. But it is important to know that this was an accident, and accidents can happen even when people are being careful. Joe did not intend for Sarah to be hurt, and he was simply playing with his friend in the park, like they had done many times before. He did not act with any malicious intent, and there is no evidence to suggest otherwise. We have proved that Joe's actions were not reckless, and he could not have reasonably foreseen the risk of causing actual bodily harm to Sarah. Furthermore, Sarah consented to the activity and as such assumed the risks associated with it. In the case of R versus Jones, it was stated, where the injuries sustained result from rough horseplay, to which the victim has consented, it is not in the public interest to prosecute the person inflicting the injuries for a criminal offence. This defence can be applied to Joe's case, as it is possible that he genuinely believed that Sarah was consenting to being pushed higher on the swings. It is clear that consent and intention are key factors when considering ABH charges. The court must take into account the circumstances in which the alleged incident occurred and carefully weigh the evidence presented to it. The prosecution has not provided sufficient evidence to prove beyond a reasonable doubt that Joe's actions were the direct cause of Sarah's injuries. The swings in the park are designed for people to play on them, and there is no indication that Joe's pushing of the swing was the sole cause of this incident. It is possible that the malfunction of the swings was potentially down to the rustiness and the age of the swings. Also, the noise and distractions on the day served to play a role in this incident. Without clear evidence to the contrary, it is impossible to say for certain that Joe's actions alone caused her injuries. In the case of R versus Savage, it was stated, the prosecution must prove that the accused intended or foresaw that his act or admission would probably result in the injury to some other person, albeit not necessarily the particular person who was in fact injured. This means that an act or omission, an act to constitute ABH, it must be intentional or reckless, and not merely accidental. Again, it is important to note that this was an accident, and accidents do happen. Joe did not intend for Sarah to be hurt, and he was simply playing with his friend in the park like they had done many times before. It is important to consider the context of the situation. The park was particularly busy on that day, with a fair bit of noise and activity background. It is possible that the noise and the activity may have distracted Joe, or made it difficult for him to see what was happening with the swings, or for them to communicate successfully with one another. In the case again of R versus Savage, it was stated, it is well established that the prosecution must prove that the defendant's actions caused the injury or harm, and that this is a question of facts to be determined on the evidence in each case. In Joe's case, there is no clear evidence to suggest that his actions were the direct cause of Sarah's injury. Joe is a young man with an impeccable past record. He is a hard-working student and a valued member of his community. Never before has he been in trouble with the law, and it would be completely out of character for him to behave in such a reckless or careless manner. He is a responsible, caring and compassionate individual He would never intentionally harm anyone, let alone his friend. Joe did everything he could to help Sarah after she had fallen from the swing, even visiting Sarah in hospital. Additionally, Joe's character and context of the situation support the argument that this was an accident and not a criminal act. The injuries she sustained were the unfortunate result of an accident that occurred during a recreational activity that was mutually agreed upon. Joe's actions were not reckless or careless, and the presence of significant noise and distractions in the park on the day of the incident serves to underscore the possibility of an unforeseeable accident. May I also remind you the credibility of Sarah's testimony has been called into question, and we ask you to consider this when evaluating your evidence. I would like to remind you again of the principle of beyond reasonable doubt, and that the prosecution must prove their case beyond reasonable doubt. And I urge you to consider whether they have met this standard in this case. If there is any doubts in your mind about Joe's guilt, then you must find him not guilty. Now that you have heard all the facts, we request the jury to consider all evidence presented carefully when making your decision and make a fair and just verdict. Thank you, Your Honour.
Thank you. Just one brief observation, and make it. You must be careful about making a kind of an assertion, like there is no question that there was no recklessness here. The way to deal with that is you may think, Your Honour, you may think. Do you see? You're both doing it. We both did a very good job, but you must think in terms of, without making an assertion, just say, you may think that the evidence suggests that there was no recklessness. Do you see the point? Okay, something to remember for all time as an advocate. All right, thank you.